So thank you for being here, everyone. This panel is a discussion about people phasing out of practice, people taking over practices. How do we go about it? What are your experiences? What do you have to say? I thought we would start by, who are you? Why are you here?
Okay. I'm Nathan Higgins, and I practice in Peterborough. I started my journey in Toronto in a tiny shoebox office in a tower, and I just hung out my shingle after being called. And as we heard from Terry earlier, it was very difficult on the legal aid front. I was doing exclusively legal aid work, just scraping by. A friend of mine from law school said, "Do you want to come and practice with me in Bradford?" I said, "Sure," and then I looked it up on the map where Bradford was. I had no idea. Went to practice there, and then had my 2 or 3 files expanded into solicitor work, but not a lot of it because I just hung up a shingle. And then at a coffee shop, I recognized Bob Evans, who was a bencher for a long time, seeing some nods, and a real gentleman. And I said, "Oh, you're Mr. Evans?" And then we got to talking, and he was looking for a succession plan. He was a 3rd generation of lawyers in the Evans family in Bradford, and there weren't any other Evans coming up to take over, so it worked out well, and I practiced with him for years, in a number of years in Bradford. And then the universe put me in touch with Doug Walker in Peterborough, who, like Bob, had practiced for about 50 years and was also looking for a retirement plan. And I was looking for an opportunity to move back closer to home. And so Doug and I got talking, and it worked out for me to take over his practice in Peterborough. And that's why I'm here.
Thanks, Nathan.
That's fun. I am Ella Forbes Chillibeck, and so I practice technically in Ottawa, and I have my own firm, but I kind of took a winding road to get there. I spent 20 years in my first career, which was a therapist, which made it way easier to work with lawyers, but it is what it is. And so then I went back to law school when I was like a bit of an old fart. And so I worked for a fairly large firm in Ottawa for about 8 years, and then I felt that I wasn't getting sort of enough litigation experience, and so I ended up moving over to another firm that was smaller. It was about 10, and then moved my entire practice over with me at that time, and then decided that really and truly, I needed to open my own firm. So I moved all my practice into my own firm and had it for quite a few years, and then decided to sell it. And so I sold my firm and had that experience, which was really interesting, and then went into in-house counsel for a few years during COVID and that sort of thing. And then came back out of it and went, oh, you know what? I really miss private practice. And oddly, I had this sort of strange contract with the people I sold my firm to that said that I had to refer work to them for 2 years afterwards and all this sort of thing. But it had been about 5 years by that point, and my firm wouldn't die. And so, for anybody that's worried about their succession planning, I mean, you really do have to sort of think long-term on some of these things. Especially, I practice in employment law, and so there's sort of a 5-year cycle that people sort of show up. So people didn't even realize I'd closed my firm in the middle. So I ended up bringing it back alive again, and now I'm practicing again in my firm. So I've kind of done everything, I think, in many ways, and sort of which is, I think, how I ended up in this panel.
That's right.
I hope.
So I'm Kelly Guerra. I'm counsel and manager in the Practice Supports and Resources Department at the Law Society of Ontario. And so you might heard of us if you've ever called the Practice Management Helpline. So we provide ethical guidance to lawyers and paralegals, and we also develop resources, some of which Priya showed, on different ethical issues. And I'm really here because all of you will be sharing practical insights, and I'm just going to be the friendly reminder that you also have professional obligations when you're transitioning in and out of practice. So I'll highlight some of those. I think there are things that you can get missed in the excitement of buying and selling a practice or the stress of that change. So I just wanted to be a part of this panel to highlight some of those issues. So thanks for having me.
Thank you very much, Kelly. Nicole?
And I'm Nicole, so I'm also from Peterborough. I own my own practice with my business partner. So I'm here because I know Curtis, and Curtis said, will you come? And I said, sure, I'd love to talk about myself. So I am here today to do that. My business partner and I have bought our practice that we run, Fox Law, in the last decade. And we also have bought 3 other practices as well during that time. And all very different kind of situations and experiences. So I'm here to talk a little bit about what went well and what we could have done better. And I'm also a corporate lawyer, and so I'm helping people buy and sell their businesses every week in a whole bunch of different industries, other professionals as well. So I'm here to give a little insight from that point of view.
That's great. Thank you, guys. So just looking at the next slide, we've kind of organized this. It seems like a lot of talking, particularly last FOLA Plenary, we were talking about the graying of the bar, and the one before that, how do we get lawyers to rural areas, and they seem to all be kind of coalescing into this issue, right? Succession. How do we go from, I'm practicing, I don't want to practice anymore, but I still need to practice, and then I'm out. And then the other side of, hey, I want to grow, it'd be nice to pick up someone else's practice and kind of run with it. So let's talk, Kelly, maybe you might have some guidance about, you had this quote that you sent me the other day about the plane, right?
Oh, yes. Just a reminder, I think that succession planning, unlike client contingency planning, which is mandatory, it's strongly recommended that you do a succession plan. But it's, as you said, really about planning far ahead and doing that as early as possible. So like a plane, you don't just land, you have to communicate with the tower, chart your course, and then descend with care. And I think that's the same sort of analogy that you can apply to coming in and out of practice, as you really need to think about, especially if you're doing your succession plan, what do you want to happen to your practice? Do you want it to be sold? Do you want it to be transferred to an associate that you've hired? But the sooner you start thinking about it, the better. Otherwise, you'll be stuck in a position where you want to get out and there aren't those options or available to you.
I think that makes a lot of sense, right? Because you can't just, pick up sticks and leave. There's like obligations that you have, and obviously you need to kind of find someone to take it on, or you can't quit yet, right?
Yeah, exactly. I mean, just like landing a plane, there's different steps. I mean, you obviously have to notify your clients. There are files to transfer or transition back to the client. And so there's a huge list, I think, of steps that I'm sure all of you will talk about that you need to consider. And so that's why I think it's important to start early and not do it this way.
Sorry, yeah.
Oh, no.
I was just going to add to that it seems like in planning, it's so specific to the lawyer's practice. So Nathan, you and I were talking about are you merging? Are you, how does that function?
Yeah, well, I just wanted to go back to the previous slide and thinking about making the connections, because this is probably in some ways obvious, but in other ways not, that you really do need to put it out there to the universe if you are a lawyer looking to buy a practice. And on the flip side, if you're a lawyer looking to retire or to transition out of your practice, you have to put it out there. Because, if I hadn't introduced myself to Bob Evans in the coffee shop, I wouldn't have had the opportunity to later buy his practice. And if Doug Walker in Peterborough hadn't told the lawyer in Midland that he was looking to sell, and that lawyer happened to know that I was from Peterborough originally and mentioned to me, we wouldn't have connected. So it's really important to put it out there and to remember that we are a community of lawyers across the province, and word can travel. So I just wanted to put that out.
Maybe like a law society buy-sell trade forum.
Yeah, that would be good.
Sort of a plenty of fish.
Yes.
Yeah, question. If you wouldn't mind, the mic is just back there.
So my question for your commentary is sort of twofold. Number one, how do you value, or what's the basis of valuation of a practice in today's day and age? And second of all, how do you get around, the concept of counsel of choice, especially in smaller markets where, I mean, in my career so far, a couple of times people have offered to sell me their practices and I declined and ended up picking up all those clients anyways. And so, and you guys are talking about being from Peterborough, I get that it's different in Ottawa, but I'm coming from a smaller region with smaller town lawyers, so to speak. What's the valuation? What's the thought process? And what's the benefit?
Do you want me to answer that?
Yeah, please.
So, in my experience, it's, to a certain extent, it's governed by the Law Society, right? And so you need to be really aware that the client, of course, is the one that's making the decision. And so your client is the person that gets to choose whether or not they go to the firm. You can select a firm that you want to sell to, and that firm can be completely happy to buy from you, right? But the way that it works in terms of valuation, it's almost impossible, right? Like, I think that's fair to say, that it really depends on, how much work's been done on the file, how much work is left on the file, whether or not, what I ran into in my firm was I had one contingency file, which was incredibly difficult to transfer because nobody wanted to touch it with a red, with anything at all. And so we ended up that I did get it transferred and that sort of thing, and it did get resolved, so that was really positive, but it ended up being a really difficult part about my trying to close down my practice. The other thing that happens is that, what you're getting compensated for is goodwill, so there's a bit of value in that, but, quite frankly, it's not worth much. And that's just the reality of it. And then what is worth something is the percentage of billables that comes in afterwards. And so a lot of the fees that you're going to get are going to be over the next 2 years as those files move forward. And you're getting a percentage of that from the acquiring law firm.
Nicole?
Yeah, and I think you have to look at the type of practice you have as well. So some practices may lend themselves a little bit more to recurring clients, or if you look at and think about a practice that has a really deep database of will clients, those eventually will hopefully become one day estate clients, right? And so there's different ways you can value different industries. A lot of times we're talking about a multiple of retained earnings. Like you mentioned, it's kind of hard, like we don't have a lot of hard assets, your computers, your furniture. So it is really putting that value on the goodwill. And so I think you need to look at what type of practice you're buying into, and then you can also look at structuring payment plans. So the first practice that Ross and I bought, we established kind of a number for that, and we paid that over 6 years. The most recent practice we purchased, I'm now paying a percentage of the clients that I've retained. And so every time I do work on a file for a client that's come over from this other lawyer, I pay a percentage. It's a higher percentage in the first couple of years and then a lower percentage. But that's the nice piece where we're talking about clients getting to choose where they go. We did notice, when we bought our first practice, we were buying from a lawyer who'd practiced for 45 years. He had a lot of really loyal clients, but he also had a lot of clients that were kind of just waiting for him to retire, and then they were ready to make a move. So going with a different fee structure where it's kind of tied to the clients I retain or the clients I keep working for has helped me so that I'm not paying for clients that I'm not going to keep. And so I would say look at kind of what the type of practice is, what the chances are of having repeat clients, and certainly discounting it a little bit for knowing that you may have an attrition number or a percentage.
That's an excellent point. When we were discussing this in kind of like our planning session, something that came up that I hadn't fully thought about was retention of the person that's releasing their firm, right? Like wanting to have them back for a period of overlap and that having tremendous value. Does anyone have some insights on that?
Yeah, I think that's really key to, if you're purchasing goodwill, it's so key to have an overlap period of some sort. In both my cases with Bob Evans and then with Doug Walker, we had different structures, but in both cases, those retiring lawyers stayed on and spent quite a bit of time introducing clients to me, which really put the clients at ease, and even people that I didn't meet, have since come in and said, oh, right, you were working with Doug. All right, well, if Doug was okay with you, I'm okay with you. So just that sort of association in that overlap period. And I don't know if we're going to talk about it, but there's different ways to structure that overlap period, which you have to think carefully about. Whether you're transitioning out or in, you have to think about the type of relationship you would like to have.
No, I think that's an excellent point too. Like, is the person that's retiring or divesting, are they staying on? Are they now your employee? Right? Like, there's all sorts of discussions about what is the post takeover merger relationship going to look like. Correct?
Yeah, and I think from a law society perspective, one thing to keep in mind is your marketing and advertising, if there is going to be that overlap, just so that it's very clear that they know what the role of that former departing lawyer, not quite departed, what their role is, so that they're not misled. They don't think that that's their lawyer if they're just of counsel or just providing some advice here and there.
What were some other considerations? Like, there's like, the goodwill that you're purchasing, but what if the practice has tangible physical assets, like a building? What if it's like wrapped in a proco or a holdco, or like there's all sorts of permutations? Like, how do you consider all those things?
Yeah, so I think some people will be looking, whether it's the legal industry or somewhere else, sometimes clients want to sell both the real estate and the practice, and sometimes they just want to sell the practice and then hold on to the real estate and have a nice little retirement amount of money coming in each month as a landlord. So we can pretty much structure a deal in just about any way. Sometimes people have both their practice. It's becoming less and less. Sometimes people have both their practice and their real estate in the same corporation. So we would engage the services of an accountant to maybe look at spinning out one or the other of those pieces before a purchase proceeded. Or we'd certainly look at maybe doing that after we close the sale to keep the real estate and the practice separate. It just maximizes flexibility going forward. If you're looking for some financing to go along with the purchase of your practice, so we've had a number of different ways we've done it, mostly through kind of a vendor take-back. But certainly, as we all know, the bank would love to have some real estate to register their mortgage against if they are giving you some financing for your purchase. So that's also a consideration. So sometimes we need to get a little bit creative, but it can be all, part, or none.
That's cool. So then, so right now, I'm kind of broaching this subject with someone, and the issue has come up that I have a paperless office, and this lawyer has 40 years of paper. And I'm like, I don't want 40 years of paper. So how do you kind of navigate those things? Anybody have any experience with paper management?
Yep. Entire basement's full. I mean, that's... in both cases of my purchases, that was sort of a part of the negotiation that I don't really want 50 years of files. And so there is a retiring lawyer is in a way receiving a benefit if a new lawyer coming in is willing to hold on to those and be the keeper of those documents, because at least in a solicitor practice, very often we are getting clients coming and saying, oh, yeah, I don't know what I did with my report when I bought my place. Can you look it up and see if there was a survey? So it's a fair bit of work involved. And so that should be factored into the consideration that you're negotiating on when you're coming up with your agreement and the purchase price. Sure.
Again, Faye Hassan from Halton Lawyers Association. I too have also purchased the practice of many retiring lawyers and also had this issue of paperwork. So maybe this is a question directed to the person from the Law Society. What is the rule on how long you have to hold documents? And is it specific to the area of law? Because I know from my negotiations, I told the lawyer, okay, go back 15 years. Anything more than 15 years, that's a you problem, not a me problem, right? But certainly, I don't even want to go back 15 years because rightly so, it is a lot of work to have to go back and dig through this paperwork that's probably not organized properly. And for retiring lawyers, they definitely are not scanned, right? So you literally physically have to weed your way through boxes and through files to try to find things.
So the Law Society doesn't dictate how long you should keep your records for. I know that's not the ideal answer, but generally that's 15 years because of the limitation period. We actually just recently updated our guide to closing your practice, and we've included Law Pro's retention guidelines because a lot of it is going to depend on the length in which a claim can be commenced. So I know for real estate that's quite 45 years or something like that is the longest. So, I mean, and it also will depend like how complex was the file. Was there issue of capacity? Then you might want to keep it longer than sort of the 15 years, but it really does depend on your practice area.
We can't hear you.
Sorry, I'll be quick. So for real estate, I understand that that's a big area where a lot of lawyers have claims on. And I understand way back when people used to actually sign a deed, you know, there might have been a reason to hold on to that. But isn't, like, I don't know, maybe you're going to come knocking on my door. I scan my whole real estate file and then I shred it. Because there's nothing in a real estate file that is original anymore. Mm-hmm. The deed is now a transfer and the original looks the same as a photocopy. People are signing electronically anyway. The documents, you know, once they sign it, even if they come in person, they sign it. I give them the originals and I scan a copy for myself. So I'm hoping that the scanned copy is enough. So I guess the only issue though, if you're taking over a lawyer that's retiring, do you take the time and expense to sit and scan them all? Or can you just put a date in the calendar where you can have a bonfire?
I think in this day and age, digitizing your files is actually a good thing, as long as they're securely protected. I mean, there's different considerations when they're digital. Nobody's saying that you have to keep physical files. I think a lot of us have moved towards electronic copies. Of course, if there is original client property, you can't just get rid of that. And I would caution even when you're buying a practice, I have a horror story of a lawyer who bought a real estate practice, but the lawyer who he bought from originally started off doing wills, and when he entered the practice, in the basement was basically a closet full of original wills from like the early 1800s or something ridiculous. And now it was this new lawyer's problem, and his first call was to us asking if he could have a bonfire, and the answer is obviously no. This is original client property. So really know what you're acquiring, because you could be surprised by what you find. But in terms of file retention, I don't think there's anything wrong with electronic versions, as long as you're keeping the file and you have access to it and it's protected.
And Faye, I would just add too, like, I think it's really important. It's a good point, and it's important that you turn your mind to it when you're contracting with that retiring lawyer, to be like, okay, 15 years from now, can I have that bonfire? Yes, they've agreed to it. And that way they're not looking to hold you liable after that bonfire occurs and there's some claim made against them.
I think there was a question over here.
Thank you. Hi, Mark Gevidoni. I have a general question, because this is a really interesting topic, because it's really focusing in on the business side of law, the practice of law, but it's a regulated profession. And so there is clearly, as we're seeing, this intersection between the regulatory restrictions or requirements, and we're wrapping a business transaction around it. So things like, if like a percentage of a fee is being paid back, does the Law Society consider that as a referral fee? Now are you constrained within the regulation of fees because that was set out in a different way? If you've brought somebody on, or somebody's going to stay on for a period of time, Are they now practicing in association with you? Are they now a partner of you? So there's this overlap, and in some way, the regulation is going to impact the business transaction. Are you aware of any checklist, material, anything that would be supportive that outlines, if you're interested in buying a practice or you're looking at selling a practice, what that might look like in terms of framing a purchase agreement or an arrangement that complies with the regulations, but also allows you the flexibility to be creative about the type of sale that you're trying to do, the business side of that sale?
I guess that's for me. We don't have any resources specifically on buying and selling practices. We do have, as I said, a guide to closing your practice. It doesn't deal with the sale, but a lot of the same considerations go into winding down a practice and then buying that practice, I would say. So, I mean, good point regarding referral fees. I have that in here about not making sure you're tying the price to each client, because that is technically then, I think, triggering of the referral fee rules, which means you'd have to enter into a referral fee agreement for all of those clients. But it's something to consider, right? It depends on how you structure it. If it's a percentage of the revenues, that's in our commentary, that's an exception to the referral fee rules. So, you have more of the practical experience in how you negotiate these transactions, but there are certainly ways to stay in line with the rules while still meeting your business objectives. But
That's a really good point, Mark, because that's just triggering me to think like, well, if you're doing it by referral fees, does that mean the retiree then can't retire and needs to still be licensed?
he still needs to be licensed, but he could still be in non-practicing status. And you
Right.
don't have to surrender your license. And that was one thing I was going to chat about too, that there are options and there are ways to stay within the community, because I think retiring is an emotional process too. A lot of it is, at least for me, a lot of being a lawyer is tied to your identity, and so that's a big deal to kind of give that up. But if you're in non-practicing status, that's good to know. But yeah, as long as you're still a licensee, you can receive referral fees. So you just have to have your license.
Hi. This may be sort of a collateral question, but in terms of document retention, has the Law Society issued what it considers best practices of what document retention looks like, given the gravity of documents being lost?
Yeah, so we also updated our guide to closing, retaining, and destroying client files. And so there is a sample file retention policy in there, as well as some guidelines of best practices. Again, the Law Society doesn't dictate how long you should keep it, but we've included, as I mentioned, Law Pro's guidance on that. So there is definitely some resources there. I don't know if you're looking for something more specific.
Well, I'm just thinking, are you building in redundancy for files that are being stored electronically? And how do you approach that?
I mean, the guidance is for both physical and electronic files. Obviously, the considerations, generally speaking, are the same in terms of security, confidentiality, and whatnot, but how you do that for physical versus electronic is obviously different. But, I mean, I guess is the question just in terms of an electronic file and how long you can keep it? I think, again, it really depends on your practice area, less so whether it's an electronic versus a physical file. I think it really, like I said, depends on if your practice area attracts a lot of different claims and complaints, how long, or the latest claim and complaint that's been received by Law Pro, sort of keeping things longer. If you had a really difficult client, I would keep that file, because chances are they might file a claim or complaint at some point. Or if your gut feeling after closing a matter is, well, I don't know, that client might come back and whatnot, then I would keep it longer than the recommended 15 years. But I don't think it matters whether it's physical or electronic. I do think that from a time efficiency and space, like storage fees and things like that, that electronic is a lot cheaper, and so maybe more practical.
Okay.
We're kind of going through that calculus right now, right? How much would it cost to digitize these
Exactly.
innumerable bankers boxes versus just letting them sit there for eons, right?
Yeah.
I did want to ask, did anyone in your transactions respectively, did anyone's divesting lawyer retain ownership of the files, or did everyone assume ownership of the physical or digital files?
So in 3 of the 4 practices, we have all the files. The most recent one that I did, basically I bought like the goodwill, and so all of her files are her files still. I'm just doing new matters for clients going forward. And so again, you can structure it the way it works best for you. Oftentimes, when we talk about a share purchase versus an asset purchase deal, we bought shares, and essentially you're stepping into the shoes of the person who's leaving their office, and you step right in and sign checks and do everything. Those files stay with the practice. They're part of the practice. Like I said, when we just, our most recent purchase is she kept all of the files that she's done work on. We have had the wills come over again, giving the clients the option of where, if they wanted them to come, and the corporate work. But any corporate work or will work that was done up until the closing date is hers. The files are hers. Now I'm opening new files as work comes.
Yeah, and I would say even from a value point, I think if you're the person retiring or selling your practice, it's probably best to go through your closed files and clean them up, keep only what you need, just because I think it's a bit of a headache to be taking on banker's boxes of files that are either closed or maybe may come back to you.
It was a wonderful opportunity to digitize everything, and I think you just have to sort of embrace that, and so what happened in my file, when I sold my firm was I kept any of the inactive files but digitized everything, and then, and honestly do everything right. And so, really. And so I did that, and then transferred over a digital copy, a digital file of to any of the active files. And that seemed to be the easiest way to do it. It also did bleed into that sort of situation though, where it became this firm that didn't die. Right. So then I had people that were coming back to me that had been my clients 5 and 7 years ago, that I still had their file, right? And so then I ended up in this situation where it was the firm that can't die.
And I'll just sneak in one kind of extra tip, now that Curtis is talking about merging kind of his paperless office with one that's very heavily papered, is also if you inherit as part of the transaction some employees from the existing practice that you're purchasing, and they're used to having these really thick, heavy paper and save copies and copies and copies. It's just working with those employees. I don't know that we'll ever be fully paperless, but we're just trying to have less paper in my office. So I have a couple of staff members that have been with the practice for 40 plus years, and just trying to help them thin out files and scan things that we know clients are going to ask for. And it's just kind of working with them. The thought of going completely no paper they will not have, but we're just trying to embrace the less paper piece. And so it's just with any employee just trying to transition and realizing change is hard for everyone. That'll be something that will come up if you do inherit or purchase as part of your purchase some employees that have been doing things a certain way.
I think you have to go to it. The one thing I wanted to say too is that if I was buying a practice, I would ensure that the digitization of those files and the transfer of those files, the cost associated with that, stuck with the firm that you were buying it from. That would be, it cost me a bunch of money to do it. I think it was worth it in the end. But I think that if you are thinking of purchasing somebody's file, you just don't want to be in that situation where you've got these boxes and boxes of stuff that are becoming a nightmare for you.
Yeah, it's just so specific on the practice you're buying, because in the case of Bob Evans' practice, I mean, he had his grandfather's files, his father's files, his uncle's files, and his files. So it would not be doable for him to digitize that. But yeah, it has to be factored into the negotiation. Should we talk more about employees, though?
Yeah, go for it, man.
Actually, my question had to do with employees, because often, I know I inherited, it's one of the reasons I took over the practice of a lawyer that had just passed, but the importance of perhaps new employment contracts, seniority when it comes to severance and things like that. I don't know if you want to touch upon that, perhaps?
Well, I don't know. I think I'm probably the only employment law lawyer up here, right?
Yes.
So I guess the hat falls on me. So, what you are going to have to look at is whether or not you are, the same employer, right? And that sort of thing. So introducing a new contract without offer acceptance and consideration is going to be problematic if you don't. Like oftentimes people just sort of show up with a new contract and get people to sign it and they sit in the same desk and they get the same pay and they do everything else, right? And they're like, oh, what do you mean I can't rely on this later on? So be careful around how you construct any of those new contracts. And then the other thing is that, you are going to be in a situation where you are going to have to recognize their previous service in terms of their ESA entitlements, in terms of all those sorts of things. And if they don't have a contract, you need to be really careful that you're not accepting somebody's 30 years of common law entitlement. So you want to be careful that way, right?
Yeah, and that's something that we also negotiated over when I was buying the practices, because I recognized right away, I'm a successor employer. There's no real way around it for what you just said. And so it was assigning the liability in the purchase agreement. Okay, so, and it's not perfect, but basically it's, if there's a wrongful dismissal or whatever.
Or even if you just want to terminate them without cause.
Right. In either case, it was like, okay, the retiring lawyer would be responsible for the portion of payment for the period of employment before I started, and then I would be responsible for the period of employment thereafter. It's not perfect, but for me, it was important to keep the employees, and also for the retiring lawyer, that was really important. For both Bob Evans and Doug Walker, his staff were
It's also
like
important
family.
for your client.
Yeah, exactly. Yeah, so he wanted them they both wanted the staff looked after, and my clients felt good because they came in and recognized the clerks that they'd worked with for years, which was helpful for me too.
Mm-hmm.
I'm
And
sorry.
if nothing else, the clerks can show you how to do the job.
That's right.
So I think we've just gone over our time, but I just wanted to give everyone like 30 more seconds to just be like, what are your imparting, what do you want to leave the room with as your last remarks on this topic?
You want me to start?
Sure.
Sure. So I think the big ones are it's going to take longer than you expect it to whether you're buying or you're selling a practice. So start early thinking about it. We are so busy with our day-to-day putting out fires and dealing with client matters, but you do need to make it a priority. And the other piece that Nathan touched on is really making sure as a purchasing lawyer, if you're buying a practice, really maximizing that time or that overlap time, if there is some, with the retiring lawyer, because there's such knowledge and the opportunity to introduce clients and do all of those things. And we could have done a better job on it than we have on a couple of the transactions. And I just think it's such a valuable piece, but it also can be a really difficult piece because you have an exiting lawyer who's now not the person in charge anymore, who is now an employee potentially, and trying to manage those relationships. But I think for most lawyers, they want to make sure that their name carries on and their clients are taken care of. And so maximizing that time and using it wisely will benefit everybody.
So for me, I would just say, remember some of your key professional obligations. So duty of confidentiality, that'll apply throughout the process. So just keep that in the front of your mind. Also conflicts of interest, which can also arise if you have staff that you keep on. So just to be aware of those. And other than that, I would just say, we have some great resources on the Law Society website. You can call the Practice Management Helpline if you're thinking about winding down your practice. We're happy to guide you through sort of all of the considerations. And specifically with trust accounts, if you're closing your trust account, closing your practice and want to close your trust account, just make sure there's zero money in there because you can't close it otherwise. But yeah, if you have any questions or things afterwards, you can come find me or you can call me on the helpline.
Joanne? Or Ella?
I guess for me, I think the one thing that you really want to remember is that it is your client's choice ultimately. So the more that you can do, if you are selling your practice, the more that you can do to make sure that that transition is positive for them and that that they can develop a bit of a trust relationship and you can transfer that, the better it is for you. I think that's important. And the other thing is I really think that people need to really be open to the idea that you can really and truly create your own practice the way you want it to be. And you don't have to necessarily fall into the bricks and mortar mold. And, there's a lot of different ways to do stuff. So be open to being creative.
Flexibility is probably one of the most important parts of the transaction, whether you're a lawyer transitioning in. If you're the type of lawyer where everything has to be sort of your way immediately, there's no type A lawyers out there, are there? That could be an issue. If you want it all to be exactly your way immediately, maybe buying a practice is not something you should do. Maybe you should just start your own practice from scratch, fresh. And likewise, if you're a lawyer retiring, flexibility is going to be needed. That lawyer transitioning in is not going to be the same as you. There will be change introduced. And so it's about that give and take from both sides to make it successful.
Yeah, I found the one thing I want to say is you have to manage your clients' expectations. So manage their expectations in terms of they're not going to get a mini me. They're getting somebody else. And that sort of thing. And try to manage that the best you can.
Thank you very much for joining us today. Thank you for taking the time.